Welcome to the Legal Lounge here on CRN Digital Talk Radio, CRNTalk.com, streaming live coast to coast and around the world. Also in stunning high-definition video on Facebook.com/CRN Talk, Tiki Live, and of course, a Roku channel and CRNTalk.com. I'm joined, as always, by the one and the only, an active attorney, U.S. Army veteran, Juris Doctorate in Law, undergraduate degree in physics, and author of a book that has proven to be a guideline for the Supreme Court now and in the future. That book, America, An Illusion of Freedom, is available on Amazon.com, Barnes & Noble, and on iTunes. Ladies and gentlemen, Mr. Richard Nixon, in the show that gives you the news you get nowhere else. How are you, Richard?
I'm pretty good. Of course, the subject on everyone's lips today is the so-called debate. And what I tried to do is play it again and again and again and pay attention to only what the former president, said and whether or not it had any kind of policy content. And it did. And so I felt that what Mr. Trump was doing was living up to the word debate. It's supposed to be an exchange of ideas. But then I went to Miss Kamala, and what I heard her do and her say is that no matter what the question, she came out with some kind of platitude, something she had already been briefed on, and simply memorized. And I understand, although I don't know this, I understand that the so-called fact checkers did it 11 times to Mr. Trump, maybe one time to Kamala. And the thing that really got me was the very first salvo, right off the chute, the man in the situation there, I forget his name.
David Muir.
Muir, okay. He asked Kamala, are things better than they were 4 years ago? And instead of saying yes or no, she launched into what she thinks she would do. And yet, as Trump later said, you've been there 3.5 years. You might try waking up the president maybe at 4 o'clock. He might be awake then, and see if he can't do that. Or the other one thing that I think that Trump missed on is when she mentions one time that she had traveled many, many places, and she found out that most people thought that Mr. Trump was a fool. Now, I don't know how you counter that by simply saying, no, I don't think they did. What he should have said, though, is, you know what, though? If you've traveled to all these places, I can tell you someplace you missed. It's our southern border. And you even admitted that you didn't go to the southern border. In fact, you were startled when so-and-so asked you the question, and you said, no, I don't know what you mean. I don't see the point. I haven't been to Europe either. I mean, come on. But it's true with everyone, though. We always look back at either a test we took or something we said we could have done better.
I should have said that.
Yeah, that's right. But he did at the final salvo. What he said was at the end when he did say that there's no question that we were better off under my command, if you will, than we are now.
Yeah, it was interesting. I want to talk a little bit more after the break, but we got a big show. We're going to talk about an interesting article from John Minen in the Daily Journal. We're going to talk about the Ninth Circuit. We're going to talk about a San Mateo judge getting into hot water, and we're going to talk about parking. So stick around, you guys. We're here in the Legal Lounge. Stay with us.
Hi, everyone. If you've been injured in an accident that was not your fault, listen up. We have legal professionals standing by to answer your questions for free. Call now and find out if you have a case and how much it's potentially worth. Call 800-745-9090. I'm here with spokesman John Wolf. So, John, tell everyone listening who should call right now.
Well, Maria, first off, thank you for having me here. It's always nice to answer the listeners' questions. Now, as far as who should call in, anyone who's been injured in an accident and think you deserve compensation, give us a call right now. 800-745-9090. You'll find out if you have a case and how much it's potentially worth.
Thanks, John. You heard it, folks. Take advantage of this opportunity and call now. 800-745-9090.
Advertisement sponsored by Legal Help Center, may not be available in all states.
are back in the Legal Lounge. Thank you so much. Talking a little bit of politics here with practicing attorney and noted author of America: Illusion of Freedom, Richard A. Nixon. And Richard, I just want to kind of circle back to some of the, something you said about the debate, that there was another missed opportunity. Do you think that from both also the moderators, were terrible, but he asked her, the first question is, were you better off 4 years ago than you were today? And Kamala had this weird answer where she's like, oh, well, I'm not Joe Biden and I'm not Donald Trump, obviously. And we saw the moderators interject a lot. It would have been a perfect opportunity for them to interject at that point to ask Kamala, well, what policies of Joe Biden do you disagree with?
Right.
What did you do to forward your agenda? And right. I think that was a missed opportunity.
And as the border czar, have you ever been to the border yet? I think she probably wouldn't answer that question.
Also, one thing that, I don't want to put my head in the lion's mouth, Richard, but it seems that former President Trump, why didn't he just list all of his accomplishments? Why did he, get stuck in, talking about crowd sizes and talking about, debunk stories? Why didn't he just, do what we've done on this show multiple times, list, 70 to 80, accomplishments over his 4-year tenure, which he accomplished even going through the COVID pandemic.
That's right. And all these lawsuits. And then maybe she called him a felon. Now, maybe that shook him up a bit. I don't know. But like we said, all of us are guilty of looking back and saying, man, I should have said that, or I should have done that. Maybe his handlers told him not to get into that. I don't know.
Yeah.
But yeah, like I said, but at the end he did say that all these things you're promising, you've been here 3.5 years. You didn't do any of them, especially on the border. You've still never been to the southern border. In fact, if you'd like it, I'll take you there. You and I can go there. We'll have breakfast, and we'll see how many people are coming across the border that are doing so illegally.
Yeah. All right, Richard, let's move on and let's talk about, we're sticking sort of with politics here. This has to do with an article written by John Minen. He is the emeritus professor at law at University of San Diego, former attorney with the Department of Justice in Washington. He's a deep state guy. He wrote something about the Electoral Count Reform Act and the risk of mass refusals to certify the 2024 election. It seems like Mr. Minen and others on the left are already kind of crying foul and saying that former President Trump, if he wins, will cheat. Your thoughts on this piece?
Yes. Well, as a result of the 2020 election, Congress got together and decided they better pass some laws because, to use John Minen's words, President Trump took advantage of some ambiguities. Of course, he had every right to do so. But part of his article says that the presidential election process involves a statewide popular vote and the subsequent electoral college vote. Under Article 2, states appoint their electors in such manners as the legislature thereof may direct. Article 2, Section 1. The electors vote for the president and vice president based on the statewide results. Now, what he's concerned with, that is Mr. Minen, is that when you count the electoral votes in Congress, Trump urged Vice President Pence to decertify the 2020 electors as part of the fake electors scheme, although Pence refused. The Vice President limited ministerial power is now clear. So my point is this. What Mr. Trump had done is he simply said to his still Vice President, who was then sitting as the President of the Senate, this was January 6th, President Trump was still president. He had an obligation to see that the laws of the country are enforced. Mm-hmm. And he said, in a nice, polite way, I hope that Mr. Pence counts the right electors, not the phonies or the fake ones, meaning the ones that came from the electors in each state, as opposed to those that came later, within 3 days after the election, which were against the U.S. Constitution, and to not count those. Now, in my mind, in many people's minds, those were illegal votes, and if you only counted the votes from the legislature, Trump won. If you counted the later ones that came in by mail, Mr. Biden won.
And when people think of illegal votes, they think of something like nefarious and we've gotten into that before. But what we're talking about here is specifically in Pennsylvania. Which, if former President Trump would have won Pennsylvania, he would have gotten 270 and won the 2020 election. But what we've talked about before is that the courts in Pennsylvania ruled against the legislature in violation of Article 2, Section 1, allowing for later counting and later mail-on drop-offs, citing COVID as the reason. And this piece of legislation, this 2022 Electoral Count Reform Act, first of all, I don't understand how this passed constitutional muster without a constitutional amendment, because it goes through all sorts of things. It says that only 1/5 of both chambers are needed to object to a state slate of electors. It appoints a federal 3-judge panel to expedite review of issues with respect to federal questions involving the appointment of electors. It significantly empowers state governors to the state executive of each state. The governor has the duty now to transmit the certification of attainment to Congress, where previously in many states it was the legislatures thereof. It seems like this Electoral Count Reform Act of 2022 is in tension with Article 2, Section 1, isn't it, Richard?
Absolutely. And of course, what Professor Minen doesn't seem to recognize is that Mr. Trump may have taken advantage of an ambiguity, but I believe properly so. He was the president on January 6th. He wasn't deposed, if you will, until the 20th of January. I said December, I meant January 6th. So what you've got in that situation is where the court, the Supreme Court of Pennsylvania, changed the law to extend the time during which a person could vote, extended it by 3 days.
Correct.
If it was done by mail. Now, they basically ignored the Constitution, which says it must be done within Election Day only and by the rules set by the legislature. I'm going to read you just one short paragraph here.
Please.
This is a document submitted by Justice Alito, joined by Justice Thomas and Justice Gorsuch, called the on motion to expedite consideration of the petition for writ of certiorari. This is October 28th, 2020, which would be a week or 10 days before the November 3rd, I believe, election of 2020. Now, this is what it says. It says a lot more, but very briefly. The provisions of the federal Constitution conferring on state legislatures, not state courts, the authority to make rules governing federal elections would be meaningless if a state court could override the rules adopted by the legislature simply by claiming that a state constitutional provision gave the courts the authority to make whatever rules it thought appropriate for the conduct of a fair election. So this is exactly what happened. The state court of Pennsylvania decided to extend the days during which one could vote for president by 3 days. It could be by mail, etc. Oftentimes, if it weren't dated, they would put a date into it. They would assume it was done timely. The point is, the state's involvement in the election in Pennsylvania and other states violated the U.S. Constitution, and as Judge Alito says, it basically made Article 2 of the U.S. Constitution that gave the power to the legislature, it made that meaningless.
It did. Indeed it did. And former President Trump, when he talked about new slates of electors, he was talking about rectifying that problem.
Right.
And I think that he had a valid point. He was given a lot of advice from counsel about that too. Stick around, Richard. We're going to talk more about this right after the break. Stay with us here in the Legal Lounge.
You're experiencing pain, back pain, shoulder, elbow, or hand pain, pain from a sports injury. If so, schedule a visit with Dr. Michael Sheps, the leading expert in laser therapy for pain management. Call 310-873-4422 or go to drsheps.com. Experience Epic T, the breakthrough laser therapy system that Dr. Sheps developed to make you pain-free in less time. Laser therapy is a non-invasive, safe, and effective in-office procedure that penetrates deep into your skin without damaging the tissue. It perfectly targets areas of pain to promote fast, natural healing. Relax your muscles, ease muscle spasms, joint stiffness, and arthritis pain while increasing blood circulation. For over 25 years, Dr. Sheps has helped Olympic athletes and sports enthusiasts alike get back in the game. Schedule your visit with Dr. Sheps at his Brentwood office in California. Call 310-873-4422 or visit drsheps.com. That's DRSHEPS.com, 310-873-4422.
Attention real estate investors. Do you need cash immediately? If you own one or multiple rental properties, you can use your equity to get cash out fast. The best part is we don't need tax returns or even a good credit score. At America's Loan Source, we are not a bank and we don't have bank rules. We make the decisions to loan you money, and there's no limit how much we can give you. Some clients have gotten as much as $500,000 or more within days. Use the money any way you want. If you own one rental property or 100 and COVID has left you in a cash crunch, we can help you turn your equity into fast cash. Call now for details and close in as little as 10 days and get the cash you need. 800-353-1760. 800-353-1760. 800-353-1760. That's 800-353-1760.
And we are back in the Legal Lounge. As always, check out all past and previous sessions. They're available on YouTube and on Rumble. Find CRN Digital Talk on both those platforms. And we're talking about this 2022 ECRA, Electoral Count Reform Act. It seems to be misguided, seems to be in tension with the United States Constitution. And that particular article in the Constitution, Article 2, Section 1, and just briefly, it states that states appoint their electors in such manner as the legislature thereof may direct. Richard, you read that earlier, and I want to ask you, as our constitutional scholar/expert, why did the founders empower the legislatures with election protocols?
That's interesting because, remember, the Constitution is, by its very nature, a document that created the federal government, empowered the federal government, and limited the federal government. Up until the Constitution, we really had no federal government. It was just a union of 13 colonies or states.
A confederation, you might say.
Yes. And many people were opposed to it because they felt, and they used the word jealous, they were jealous of their powers. They didn't want to share their powers with anyone, except that they recognized that some things were by their very nature uniform, like we should all have the same coins. We should all use the same money. We should also have the same position vis-a-vis foreign states. We can't have one state fighting Louisiana and another state saying, no, we want peace with them, and so on. So there's some things that are inherently national by their very nature, and that's what the founders attempted to do. And one of the other overriding things is they really believed that this country should be run by the people. And to that extent, as one reads the Constitution, they see little places where a legislature is interjected into certain areas where you might think it's strictly a federal problem, and this is the one. In Article 2, as you just read again, Mike, it says that it's up to the legislature to pick the electors from each state and send them to the federal government for counting. They actually go to the president of the Senate, who in 2020 was Vice President Pence. So there's nothing in there that suggests that the judicial review. There's nothing in there that suggests either the governor or the courts or anybody else is supposed to get involved in that situation. It's supposed to go directly from the state legislature, all the states, all 50 states, to the president of the Senate, in our case, Mr. Pence.
And why specifically the House of Representatives, sort of state legislatures, because that body is closest to the people, correct?
Exactly. They really represent the people. There's something like 435 of those people. And it's up to those people. They are really accountable to the people, and this is exactly why the founders decided that that's where that power should rest, with these people who are accountable to the people.
And going back to this Minen article, just to wrap up here, he at the end of this article, he talks about this nightmare scenario that the Trump campaign is going to try to kind of wait out the counts in order to establish something under the 12th Amendment contingent election theory.
Well, without reading the 12th Amendment, because it is quite lengthy, basically what the 12th Amendment says is that for some reason, if the Electoral College is unable to, if neither party, whether it be the Democrat or the Republican in our particular
if no one gets to 270.
Nobody gets to 270, or it's a tie, they both get 269 or whatever, then it falls into the House of Representatives, and they then, for the president, it falls into the Senate for the vice president, and they must literally, since they've already counted and they've got a situation there, they then take ballots and count. And it's my understanding, if I didn't misread it, that our buddy Thomas Jefferson, it went through 35 counts before he was finally elected.
I can't believe they did that to TJ.
Yeah.
That's shameful behavior, Richard.
Well, you can check that out, Mike. But anyway, that is what Mr. Minen claims he's worried about, that somehow Mr. Trump is going to fool around with something and make sure that those things, that those electoral votes that the legislature of each state has amassed, somehow they don't send them in a timely manner, too late for any court of that state to resolve the issue, and boom, it ends up in the
Republican-controlled House of
Representatives. But you and I had an interesting, I think, discussion regarding
hold your fire on that, Richard. Yeah. We're going to come back right after the break and talk about that. Stay with us.
Attention pet lovers. Try Greska's Carbon 60, a revolutionary pet supplement designed to keep your furry friends at their very best. It's packed with powerful antioxidants. Greska's Carbon 60 supports your pet's immune system, joint health, and vitality. Now, whether you have a playful pup or a seasoned senior, give them the gift of wellness with Greska's Carbon 60. Visit our website at C60.com. That's the letter C, the number 60.com, or call 720-600-6040. You can learn more and order today. Your pets deserve the best, so give them Greska's Carbon 60, because a healthier pet means a happier you. Go to C60.com or call 720-600-6040. C60.com or 720-600-6040.
No more mold, no more damage, no more outdated old bathroom, no more slipping and hurting, no more stress. Make your ordinary bathroom extraordinary for only $99 per month. New shower, new door, new tub, new wall, new anti-slip technology. Be stress-free. Call 800-973-5411. BCI Bath and Shower is made in America for the highest quality. Ask about our military and senior discounts. Your dream bathroom in as little as one day. First 50 callers save $1,500 on a never clear glass treated door. Call now for free premium color upgrades. 800-973-5411. Call BCI Bath and Shower, the leader in bathroom remodeling. Be smart, safe, and stay a step ahead of inflation with our interest-free financing options. Call 800-973-5411. Love your bathroom with free upgrades. Call 800-973-5411. 800-973-5411.
The Kaanapali Beach Resort Association is reopening and is welcoming guests. While some properties are opening sooner than others, all properties are taking reservations, and we look forward to your return. Go to kaanapaliresort.com for all the latest and up-to-date information on what's happening at Kaanapali Beach. That's Kaanapali Beach on the west side of Maui. There's so much to do. With a short drive from Maui Airport, we're on the tropical side of Maui and offer breathtaking scenery, an incredible array of delectable dining, and activity choices to meet your needs. We invite you to visit Kaanapali Beach Resort, but please be sensitive to the devastation that our beloved West Side community has suffered. Lahaina is closed and will be for some time. Come to our open areas and support us as we adapt to a new way of life without our beloved Lahaina. Come visit the west side of Maui, Kaanapali Beach. Visit us online at kaanapaliresort.com. That's KAANAPALI resort.com.
Are you ready to make a difference for the environment while helping the visually impaired at the same time? Then donate your vehicle to Heritage for the Blind today by calling 800-785-9618. Every donated vehicle will either be properly recycled in an eco-friendly manner or given a new life through reuse. Donating your vehicle is easy. Simply call 1-800-785-9618 and Heritage for the Blind will do the rest. They'll even arrange for your vehicle to be picked up at no cost to you. And for a limited time, when you donate your car, you'll receive a $200 restaurant voucher and a 2-night, 3-day hotel stay at one of 50 locations. Call 800-785-9618 right now to schedule your tax-deductible vehicle donation and make a positive impact on the environment while helping others. Heritage for the Blind, where every car donation counts and every person makes a difference. Call 1-800-785-9618 now.
And we are back in the Legal Lounge. Once again, thank you so much for joining us. Make sure to check out Richard's fantastic book, America, An Illusion of Freedom. It's available on Amazon.com, Barnes & Noble, and on iTunes. And Richard, I interrupted you before we hit the break. Please continue.
John Minan's conclusion here, that he says that although each state has a strong incentive to meet these deadlines, that is to submit the electoral votes to the President of the Senate, it is not clear what would happen if a state or states fails to meet the deadlines and timely judicial review is unavailable. He goes on to say, Trump and his allies may seize on this soft spot in attempting to delay state certifications beyond the deadlines. If successful, this might toss the election into the House of Representatives under the 12th Amendment contingent election theory, which applies when no candidate receives an electoral college majority. And as we said, this is what happens if you don't get, no one gets 270, or you have a tie where both get 268 or some other number.
And you brought something to my attention that's absolutely fascinating. So the 12th Amendment, yes, if no one gets to 270, and there's 538 electoral votes, so it is possible for a 269 tie.
Absolutely.
That it goes to the House of Representatives, and then they vote for who's going to be president. But who votes to be vice president?
Well, that's right. It's the Senate that does the same kind of vote.
And so you have if it's status quo stays the same, and we have a Republican-controlled House of Representatives and a Democratic-controlled Senate.
That is correct.
We could have either a President Harris, Vice President J.D. Vance, or of President Trump and a Vice President Tim Walz.
That's exactly right.
Which would be kind of funny.
Yes, and I think it's happened before, but I don't know if it was because of this tie, but I think it was traditional that many times the Vice President would be from the opposite party, and that's something else your crack research staff has got to check out.
I'm going to put that on that right now. All right, Richard, let's just briefly, let's talk about some of the fallout depending on who wins this presidential election. And this has to do with appointment of judges. right now, the Ninth Circuit, which is traditionally been one of the most far liberal of the courts of appeals,
Right.
But President Trump, through his appointments, they've whittled that down, but it's still a 16-13 Democratic majority.
Right.
So if Trump does win the presidency back and the Republicans flip the Senate, we could see the Ninth Circuit go completely to the right, correct?
Absolutely. And that, of course, is what the Democrats are afraid of. Not only that, but if he becomes president, and some people are saying he might even take the Senate with him, he will be in a position to, because there are a few justices that are up in age, he might be able to appoint one or two more. And Justice Thomas might do it for him as a favor to make sure that Trump does pick some young conservatives. So this is going to be interesting. I can only hope that Mr. Trump hangs in there and wins.
All right, speaking of judges, let's talk about a judge in San Mateo, which is in Northern California. This judge is named Susan L. Greenberg, and she just got admonished in public, which is extremely rare for a sitting judge. Richard, what did this Judge Susan L. Greenberg do to get her in such hot water?
Well, she had a situation in front of her. It was simply a TRO, a temporary restraining order. And it's a bit confusing because it looks like it had started with some other judges and it went to another judge, finally to her. Now, basically, Judge Susan Greenberg of San Mateo Superior Court was publicly admonished Tuesday by the Commission on Judicial Performance for disregarding a litigant's fundamental rights. She refused to let him be heard at a civil harassment restraining order hearing, though he and his attorney were present and ready to prepare. Now, we've talked about due process so many times that we all have due process rights, which means we have a right to get to receive notice and an opportunity to be heard. This is what she denied this poor defendant. Now, this was the second time that this judge had been admonished. The first time was, if you will, simply a private admonishment, meaning the hierarchy as far as the state bar goes is that the first time you do something wrong, the state bar does it privately, so really no one knows about it.
So, just to interject here real fast, Richard. So this is what this judge, the court, known as the court, said that kind of got her in hot water. Unfortunately, I was informed that at 9 o'clock, when this case was called in front of the presiding judge, Judge Davis, the only party that was present was the petitioner, Ms. Lopez, and that you did not arrive until 9:32 this morning, so your client will be not permitted to be part of the proceedings this morning.
Yes.
And this is what's confusing to me. So when she said your client will not be permitted to be part of this proceedings this morning, is that a default? Am I using the right terminology there?
Well, yes, and that's exactly the point that she claims, that is Ms. Greenberg. She claims that the previous judge told her that this was a default action. And for those of you who are not familiar with the default case, where plaintiff files an action against the defendant in civil actions, especially in this case, a TRO, temporary restraining order, eventually the plaintiff will get a default judgment, which means that the defendant, to use the vernacular, is out of court. He cannot, even if he appears to the court, he cannot be heard because he already had his chance, he didn't speak up, and now it's strictly the plaintiff's case. And the plaintiff now does not necessarily win. He must, at a prove-up, he must actually prove that even though the defendant has no defense, or at least cannot present it to the court, he wins. Now, for an example, plaintiff claims defendant owes him $500. Defendant doesn't answer, he just totally ignores the whole thing. Plaintiff takes a default judgment. He goes to court. And he says to the judge, this person owes me $500 because he broke my window in my car. And the judge says, just for the sake of argument, how did this happen? And the plaintiff says, I don't know. I didn't really see it. Well, then how do you know the defendant broke your window? Well, because we had been fighting for the last couple of weeks, and she was mad at me and so on. The judge says, that's not convincing that she did it. Therefore, judgment for the defendant. Now, that happens quite often. But in any event, in this particular case, she says she thought it was a default judgment, in which case she would have been acting properly to a certain extent. However, the powers that be reviewed that testimony and said there was no default judgment.
So she might have actually been a little bit dishonest there. So we're going to talk more about this right after the break. Stay with us.
These are the sounds of Columbo's Italian Steakhouse.
Look at this ribeye. You see that ribeye?
Fantastic. Incredible.
This is delicious.
Sausage and lentil soup, special today. Very, very good.
Look at this garlic bread. Best garlic bread I ever had.
And here's Vic Perino, owner and operator of Columbo's.
A lot of the Italian recipes are my uncle's own recipes. We have a lot of people coming back for his hand-rolled lasagna. We make it basically from scratch. I think ours is exceptional.
Here's Vic on what makes Columbo's different than any other Italian restaurant.
The other thing that sets us apart from other Italian restaurants is that we're an Italian steakhouse. We specialize in our steaks.
Plus, there's more.
They're coming for a lot of reasons to value. Their value per dollar that they're getting, plus coming into a neighborhood-friendly place. Sometimes we're actually accused of being the melting pot of Eagle Rock.
Columbo's in Eagle Rock on Colorado Boulevard, 323-254-9138. Mangia.
If Ernest Hemingway was alive today, would he say this to you?
Shakespeare, Mark Twain, Edgar Allan Poe, all great writers. And after reading your book, I simply must add you to the list.
Wait, you don't have a book yet. So make a free call to Page Publishing. Their expert staff can help you turn your book idea into a real book, a masterpiece that could someday make the bestseller list in hard copy and digitally all across the world. Page Publishing can help you completely take your idea for a book, write it, and publish it. So if you want to join the ranks of some of the most famous authors in the world, call now for a free information kit. Turn your book idea into publishing gold. Make a free call right now to Page Publishing.
800-378-3212. 800-378-3212. 800-378-3212. That's 800-378-3212.
And we are back in the Legal Lounge. Once again, thank you so much for joining us here. And I just want to wrap this up before we move on to the biggest issue of the day, Richard, which is parking tickets. We're talking about this San Mateo judge, Susan L. Greenberg, who got mad at an attorney who was late to her court. And this was 32 minutes late, and this was during COVID, too. And so the defendant and the attorney were a little bit, didn't know where to go, what to do, whatever. And some of the language here from this judge to this attorney is quite salty. She says, Judge Davis is very clear. I completely understand what you went through this morning. You did not call that department. You did not notify them that you're going to be not on time. That's absolutely unacceptable. The attorney, Your Honor, there's a lot of testimony that this court needs to consider that completely contradicts and undermines the credibility of this petitioner. The judge, I understand that's not going to happen this morning, so I'll continue my orders that I am issuing. He then asked for a continuance, which was denied.
Now, but did you get that he didn't even try to tell her why he was late?
Mm-mm.
So, and that pissed her off too, probably, because he should have at least said, Your Honor, my car blew up or something, or my client got sick or whatever. But all he said was, Your Honor, we've got a lot of evidence that are contradicting what the plaintiff says. That doesn't get it either. So this is kind of a lukewarm situation. I think if I were the judge in this case, I might even lean toward her, because the guy was late and gave no reason for his being late.
Mm-hmm. This also wasn't the first time that she's been admonished, but this is the first time she's been admonished publicly.
Exactly.
And so that's kind of how it works. Like, first privately, like, you get a little, don't do that, and then you keep messing up, and you can actually get disbarred as a judge.
Absolutely. Eventually you can. And one of the reasons I brought this case up, Mike, was to show that these judges are not free to do anything they want.
Yeah.
They have to go by professional rules of conduct. And the audience should know now that if they have a judge that's done something that they think is incorrect, they can always blow the whistle and see how it goes.
And you take that up with the state bar, correct?
Yeah, absolutely.
Okay, Richard, let's talk about parking tickets in the Eighth Amendment.
Yes.
This is a Ninth Circuit case. This comes out of Los Angeles, and the Ninth Circuit revives a suit that says L.A. parking fines, late fees, are unconstitutional. Richard, your thoughts. Take it away.
Well, only that. Now, this is an article by Craig Anderson, and as we know, Mike, he always tells us when he describes the judges that who appointed the judge. This is a Judge Lee appointee of Mr. Trump, and he's basically taken the position that it's a violation. I thought we just got rid of the Eighth Amendment, but now we're back in, but this is a different situation. He's claiming that in San Mateo, where the initial fine for some kind of parking fine was $63. He was then assessed 100% as a penalty of another $63, and this particular judge said, nope, that's too much. It's a violation of the Eighth Amendment, not cruel and unusual punishment, but the fact that
excessive fines.
Excessive fines, thank you, Mike. And so that's his position. And interestingly enough, there's another Trump appointee on the other side, joined by a Clinton appointee, who say, well, look, we have every right to collect money for revenue purposes too, not just for punitive purposes. So we find that it's okay, and therefore the ruling that the circuit revives this suit, which allows it to go forward.
They kind of let the cat out of the bag when they said that, though. When they said this is not about deterrence, this is about revenue generation, and that's okay.
That's right.
That doesn't sit well with me.
No, and it's happened to me many times at parking around the courthouse. Let's say there's 20 available spaces because you get there and no one is there. And you park and you're a little late, you come out, you've got a ticket. You look around, you're not depriving anyone of a parking place because there's 20 other parking places available. Yet that's supposed to be the whole point, that if you park overtime, you're depriving of some guy who needs to get in your parking space.
Yeah.
Well, you don't have that situation if there's available spaces in that area, yet you get a ticket anyway, and you can argue that till you're blue in the face. And if you say to the judge, Your Honor, now I realize that you're only getting these fees just for revenue. You're not doing it to prevent us from parking overtime. They won't admit it. But they got some to admit it here under oath.
Well, we have a Trump appointee, Mark J. Burnett. He says he dissented and argued that the majority does not explain why revenue generation is illegitimate and fails to cite any case which found that so problematic that it tainted any other purpose in implementing a fine or fee. I didn't like what he said there, but the next thing he says, though, is he says the majority places our court as an overseer of state and municipal legislature and executive authority and mandates federal court civil rights act review for the most routine of municipal decisions. So he's saying two things. He's saying, yeah, revenue generation is cool, but he's also saying, look, this is what the legislature wrote. We really shouldn't get involved here because, as you know, the legislature is the one that should call the shots.
That's right.
So this one's a little bit tough. They did, have some testimony from two high-ranking city officials who under oath said that the city enacted the late fee solely to generate revenue. And this is 100% markup, Richard.
Exactly.
100%.
And the other interesting thing, of course, is that in the appeal, they cited a 1998 U.S. Supreme Court decision that found asset forfeiture violated the excessive fees clause if it was grossly disproportionate to the gravity of the defendant's offense. And they cite a case, U.S. versus Bajikagian. For those who are interested, 524 U.S. 321, 1998. And I think that's the case that basically set punitive damages that could be no more than 9 times the compensatory damages in a personal injury case anyway. So the court has basically taken a position. Now look at this case. This is way more than 9 times. This is 100%. The initial fine was $63, and they added another $63. without any justification. Where in the hell did they get that number from?
Yeah, and we're going to talk more about this right after the break. Stay with us.
And stop the late fees. If you qualify, please call our special debt hotline number right now for a complimentary free 5-minute consultation. Deal with your credit card problem now before it gets much worse and put more money back in your pocket. Trust me, I've been there too. Call right now.
800-475-7125. 800-475-7125. That's 800-475-7125. Attention real estate investors. Do you need cash immediately? If you own one or multiple rental properties, you can use your equity to get cash out fast. The best part is we don't need tax returns or even a good credit score. At America's Loan Source, we are not a bank and we don't have bank rules. We make the decisions to loan you money, and there's no limit how much we can give you. Some clients have gotten as much as $500,000 or more within days. Use the money any way you want. If you own one rental property or 100 and COVID has left you in a cash crunch, we can help you turn your equity into fast cash. Call now for details and close in as little as 10 days and get the cash you need. 800-353-1760. 800-353-1760. 800-353-1760. That's 800-353-1760.
Attention, this is a public notice from the Social Security Disability Helpline. If you're one of the millions of Americans who are disabled and unable to work, you may be eligible for disability benefits from Social Security. Receiving benefits is your right. If you suffer from physical or mental disability, whether you're applying for the first time or you've already been denied, we can help. We'll evaluate your situation and deal with Social Security on your behalf. Best of all, there's no fee until you receive your benefits. Remember, we only get paid if you win your case. There are many reasons and conditions that may make you eligible for disability benefits. Many of them you may not be aware of. So if you're disabled and unable to work, call now to get started with your free, no-obligation consultation.
800-559-4185. 800-559-4185. 800-559-4185. That's 800-559-4185.
And we are back in the Legal Lounge. Once again, thank you so much for spending some time with us. And we're talking about these Eighth Amendment issues regarding 100% markup on late parking fees. And someone who's gotten their fair share of parking tickets, it's also 21 days. Usually you have to pay in 21 days.
Exactly.
And then if not, it's doubled. And then let's say you're just like, well, I'm not going to pay. Well, they're not going to let you register your car.
Yeah.
And so then, you get in this cycle where you're driving around with an unregistered car, you get pulled over and you go to jail. All right, Richard. 100% fines. I mean, we talked about this before the show, and late fees and all this kind of stuff. It seems to me when you double the fine, that doesn't make sense to me. If you want to charge me interest on the fine owed, I'm fine paying that off.
Yeah.
But when you double it as a quote-unquote penalty,
right?
I don't like that.
Well, that's right. And when you push it, no one can justify that. In California, it's a windfall if a plaintiff has a judgment against the defendant doesn't pay, the plaintiff has 10% interest that accrues every year on that judgment. It's a windfall for the plaintiff. Oftentimes the plaintiff don't want him to pay because where else could he get 10% on his money?
That's good. That's a good return right there.
That's right. And those things are enforceable in court. I've sat in small claims court as the judge many times, and I will enforce an interest amount against the party. However, when there's a plaintiff there and he's the defendant and he's saying, Your Honor, they're charging me $59 a month, and I think, what is that all about? I'll have the plaintiff there who's charged him that much money, and I'll ask him if they can show me why you have to charge the person. Where did you get $59?
Exactly. I think that's one of the arguments that this suit talks about.
Yeah.
Is that there's not like there's a harm being done to the state or anything like that.
Now, interest, yes, but those things, basically, those so-called penalties and extra charges, they are not enforceable in California, and that goes for credit cards and all these other things. If you try that, you might find out that they'll back off.
Just to circle back to equal protection, we got about 2 minutes left. I know this is, a kind of an asinine question, but someone said, a wise person said, shouldn't there be equal protection between rich and poor?
Well, yes. I don't know how to answer that question, because unless we could have a constitutional amendment that expands the 14th Amendment, because the only place in the Constitution just after the Civil War, 1868, is the 14th Amendment, which talks about equal protection, and is really talking about the former slaves versus the non-slaves, that they have to now be, in criminal matters, they must be treated the same. However, of course, our liberal justices, at least they used to be liberal, have taken that concept of equal protection and extended it to man versus woman, et cetera, et cetera. And who knows? Some people have said, yeah, we do need to distinguish between wealthy and poor and so on and treat us all the same. But then you're bordering on socialism or communism, whatever you want to call it. And so far we haven't taken that leap.
All right, here's my idea, Richard. My idea is that, okay, you get a parking ticket, a violation.
Yeah.
If you're in a Bentley, you got to pay a little bit more. If you're in a VW Bug, you got to pay a little bit less.
Well, you see, that might work in the state because you don't have to necessarily rely on equal protection, because equal protection is only going to apply if you're talking about the federal government.
Exactly.
And this thing over here was the Ninth Circuit, see? So that could work. And if we have time, or maybe we don't, we can talk about Kamala's idea for unearned capital gains.
Oh, we're going to talk about that next week. I got in a big discussion about that last night. We're going to talk about that and more next week. Richard, we're out of time. Thank you very much.
Thank you very much.
And we'll see you guys next week here in the Legal Lounge. As always, make sure to check out all past and previous sessions available on YouTube, also on Rumble. Find our Sierra Digital Talk on both those platforms. And we'll see you guys next week here in the Legal Lounge.